Hi, this is June Stanley, and this is my EDL 850 Module 13, Tort Liability. A tort is a wrongful act or an infringement of a right, and it leads to civil legal liability. This is rather than criminal liability. Defamation is a common case made against schools because they've misused students' records. They've told them about something confidential or let people see the records that shouldn't have been allowed to see them. Some other things schools have been sued for. Negligence is by far the most common, and there's a lot of different ways that a school can be sued for negligence. My first case, Mitchell v. Cedar Rapids Community School District. This was a 9th grade special education girl, fairly low IQ, but she was determined that she could handle most of life's skills, except maybe money management. She started to develop a romantic relationship with an older boy in school. Her teacher noticed this, but her IEP did not specifically state that she had to be monitored out of the classroom. She and the boy left school early, and he subsequently raped her in a garage. The mother sued the school district for damages, and the district was deemed negligent for inadequately supervising the student, and damages were awarded of $500,000. That's a pretty big chunk for a school. I think these cases must be very difficult to rule on. From what I see, the arguments for and against on each one of them, most of them could go either way. It depends on the arguments. It depends on the judge. In this case, the court determined that there should have been more steps that the school had taken, and they said that other schools would have taken these steps. To me, they seem fairly extreme, except perhaps in the case that this was a special ed student and a young girl, and she was noticed in a kissing in the hallway with this romantic relationship with an older boy. So perhaps there should have been more supervision there. Some of the steps that the school could have taken, I think initially the IEP should include whether or not the student needs monitoring out of the classroom. With special ed students in particular, notify the parents immediately if they're missing, and notify office staff so everybody in the school knows. I'm not sure how this would work with all students, but certainly special ed students. It's real easy to get sued in special ed cases. The reactive measures immediately increase the monitor students, and criminal measures for the male student who raped her, and counseling for anyone who might have been involved and might be suffering emotionally from that. My second case, Pierce versus Hearn Independent School District. Now this one was decided for the school, and yet I can hardly believe that. A principal allowed a teacher to bring students to work on his farm without the parents' permission. And I'm not sure of all the background of that, but that sounds like something that as a principal I would certainly not do. While the student was at the farm working, the teacher told him and another student to take the ATV and go to another farm to deliver a tool. The student lost control of the ATV, he crashed, he died, the other student survived. And so the teacher, he didn't make sure the kids had on any safety equipment, he didn't instruct them in how to ride the ATV, and yet the court found that the allegations did not show deliberate indifference. That I agree with, but poor judgment, incredibly poor judgment, and negligence. And so the court did not charge the teacher, the principal, or the school district. It just seems that these would be so difficult to tell how the court will rule, and for that reason, the school would have to do everything it could to protect itself. Reactive measures, review of policies immediately, and then proactive, train staff on liability issue and make policy on what to do in cases like this, student-teacher relationships, permission slips, off-campus activities, because the results in this case was the death of a student. My third case, Johnson & Johnson's v. School District. This was a boy, a first grader, who was participating in a London Bridge game, and it was the first time the students had played it, and he was the first student to be swung in other students' arms. So while he was being swung, the teacher had his back to him writing on the chalkboard, probably a whiteboard. I'm dating myself. He testified he was swung fast and hard. He asked the students to stop. He asked for help twice, but the room was very noisy, so he couldn't get the teacher's attention. So what happened is he was flung into a bookcase and hurt pretty badly, disfigured. He still has headaches. He required 50 stitches. And so the court did fine for Johnson and awarded his expenses and pain and suffering. It doesn't seem like a lot of money in this case for this. And so I agree should have been awarding damages only because the teacher was not watching a first grade group when they're doing a potentially dangerous activity like this. And, first graders get kind of rambunctious. And so immediately the teacher should be counseled, and all games and activities like that should be stopped until you can develop policies to make sure that it doesn't happen again. Another thing would be to have aides who might go from classroom to classroom. Teacher could say, hey, I'm doing this activity. Can you just come in and be another set of eyes for me? My fourth case, Mosley v. Portland Public School District. This one is pretty horrific. I've always taught in rural schools, and yes, we have fights, but knifings, boy, now I teach in a prison, and it's more commonplace there. So a 15-year-old girl got in a fight with another girl during lunch. The other girl brought out a box cutter and stabbed her in the face and chest. She was hurt pretty badly, and her mother sued the school district for negligence. There was a security guard on campus, but he wasn't there in the lunchroom. And schools only have so much money, and having a cop alone, just one cop, is extremely expensive, even if the city or the county helped out financially. So Oregon law states that if that schools are immune from liability, and that there wasn't enough evidence to support the claim that the school was negligent. And so I don't know if I agree with this. I think both sides had a good case, but it seems to me that a lunchroom should have more supervision. If not a security cop, then some staff member that can pick up a phone real quick and get some help. So there's a lot of things a school could do. They could find out how students are responding to conflicts. Do they have skills to work them out without violence? Is there peer pressure to resort to violence? They can immediately assign at least some personnel to the lunchroom and other likely spots where things might happen when kids aren't in class. And you might develop policies to see if you can catch weapons on their way in. That would vary greatly from school to school. And develop programs where people can learn to talk out their problems. A lot of students may simply not know how to do that. My fifth case, 10-year-old boy, so we're fifth grade, fairly young, but not a first or second grader. He left school early. He got hit by a motorcycle and was injured seriously. His mother says she suffered physical and emotional injuries when she saw him in the hospital, and she sued for pain and suffering and for the medical bills. And this one's, to me, very borderline because the student left early. It's pretty difficult to monitor every single student and respond immediately if a student is missing. However, this is a fifth grader. That's pretty young. So the court initially dismissed the case, but it went to the California Supreme Court, and that ruling was reversed. There is a law on the books in California saying that schools aren't liable for students' injuries off campus. However, the Supreme Court argued that that did not apply to students who were negligently supervised. So it did find the school district to be negligent. And I have to agree, a fifth grade boy shows up missing in class. As a teacher or an administrator, I would be very alarmed. I think that's unusual for students that young to just come and go as they please. And so I think schools need policies on exactly what to do, and teachers have to be trained to realize how liable a school can be. There would have to be better supervision of the students, and teachers would have to know exactly what to do in any given circumstance. Professional ethics. Liability for schools is such a big one when I think of all the things that go on, and I think of all the things that can happen, all the potentially horrible things that can happen to students. It's really difficult to control all of that and to respond effectively to all of that. And yet schools would really need to develop plans and develop trainings to make sure that they can catch every possible thing that they can. And even if something bad does happen, at the very least, a school or school district can show all the things they've done to prevent it, to prevent being found liable. My references. Thank you very much for listening.